This is Michael Popok, Legal AF. Are you sitting down? You know who's not sitting down? Donald Trump's lawyers, because they're going to trial on Monday to defend against an over $400 million civil fraud case in front of Judge Engoron in New York State Supreme Court because the Appellate Court just denied Donald Trump's motion to stay the case and postpone it. Monday, no jury, just a judge. Let me set the stage. Judge Engoron, who just on Tuesday granted the motion for summary judgment brought by the New York Attorney General Letitia James, finding persistent fraud in all aspects of Donald Trump's business operations and finding that he, his senior executives, his senior male children all committed fraud as a matter of law, with no need for a trial. So when Letitia James just about a year ago in September filed her complaint against Donald Trump, her petition under New York's very robust, very muscular 63-12 executive law, which since 1956 here in New York has allowed the New York Attorney General to go after persistent fraud, shut it down, get injunctions, claw back money that belongs to the people of the state of New York, put people out of business, dissolve assets, and so much more. That's what the New York Attorney General, when they get in that chair, that's the power that they have. Part of the law in the area that gives them that power was developed by a case involving Donald Trump himself in 2016 when he was running a phony university, Trump University, that got shut down by the New York Attorney General. And there's a reported case, a precedent in the area from 2016 that establishes the power of the Attorney General to use her powers to go after fraud under this statute. Isn't that ironic? The very law that he developed in 2016 is now being used against him. So she filed the petition. It had in it 7 counts, 7 claims. The first one, what we call the standalone 63-12 claim, is for persistent fraud. And the judge already determined that on Tuesday without the need for a trial. He heard enough. He saw enough evidence. Now, what's left? Well, the judge said, we got a few more counts here. He says, I'm only granting it. You only moved, Madam Attorney General, on 1 count, but you got 6 others. The others are for insurance fraud under this same statute, for fraudulent financial statements being used by Donald Trump. That's there. And for fraudulent business records. Same statute, for instance, that the Manhattan District Attorney is using against Donald Trump in a criminal prosecution for Stormy Daniels in the cover-up affair. This is a civil case, meaning it's easier for the Attorney General to prove her case because the burden is much lower on her. All she's got to prove by the preponderance of evidence. The scales of justice just slightly tipped in her direction. She wins, as opposed to a criminal case in which you have to prove the prosecutor's burden is beyond a reasonable doubt. So there are crimes in here, in her pleadings, in her case against Donald Trump and his family and all of the executives that work for him, but the crimes are embedded within the civil fraud, and therefore she gets the lower standard. Now, this whole fight has been over whether Monday's trial was going to take place at all, right? Now that I have all the counts in there, and the other aspect of the case that was left over, you might be thinking, well, if he granted summary judgment, why are we talking about a trial on Monday, Popok? Because there's 6 other counts left: the insurance fraud, the fraudulent financial statements, the fraudulent business records, and conspiracies around all those counts. And more importantly, it's what the Attorney General is looking for the knockout blow to give the death penalty, corporate-wise, to Donald Trump and all of his professionals. For instance, you may have heard that the judge already dissolved the certificates that will allow Donald Trump and all of his companies to operate in the city of New York, ordered them dissolved, ordered them liquidated, and established and appointed a receiver or a monitor independent to take control of over all the companies and their assets and issue reports to the judge. That's going to be Barbara Jones, former federal judge Barbara Jones, who's already for the last year been a monitor over all of Trump's business affairs because the judge already found on an injunction 6 months ago that Donald Trump was committing persistent fraud. Same person, same monitor. Now her job just got a lot bigger. So that's what the judge did on Tuesday. But that's not all the New York Attorney General wants. She wants the money back. So when in her case that she's made out already, Donald Trump hyperinflated his assets and his personal wealth by almost $4 billion. And then he had bad habit of fraudulently, in her view, cooking the books about his value, his personal worth, net worth, his balance sheet, by overinflating ridiculously, picking numbers out of thin air for assets on his balance sheet, and then deflating it at the time he wanted to get a tax break. That'd be like you and me, you own something, whatever that something is. It has a value. The market has set a price for it, whatever it is. Okay. And so let's say the value of that is $200,000. And you, every year, in order to get a bank loan, you put it down for $200 million. Just a slight miss with the decimal point or the commas. You put a $200,000 asset down for $200 million. It's about what Donald Trump did. He was overstating assets by magnitudes of $300 and $400 and $500 million to get bank loans. So that he was getting bank loans at lower interest rates because the banks thought that they were more secured with assets than they really were, and they gave him the benefit of a lower interest rate. Plus, they let him borrow more money that he was entitled to because he didn't have the assets to back it. That's the case. And then he committed insurance fraud because he over-insured property that wasn't really worth that much. And so the insurance companies have this, if something happened like a catastrophe or like a little fire, they'd pay out on the higher value, not on the true value. And that's called insurance fraud. And then he doctored up his personal financial statements and his statement of financial condition, his SFCs. That's a fraud. And then he cooked it on his books. That's a books and records fraud. See where I'm going with this? So what does Letitia James want? Popok, tell us. And what is the trial about on Monday? The trial is about shutting Donald Trump down from ever taking out money, borrowing money in the state of New York, ever buying new property in the state of New York, ever being an officer and director of any company in the state of New York. Need I go on? Do you see how this could overturn his entire perception of being a successful business person? If he can't buy property, borrow money, operate a business, and permanently ban, that's bad. That's Monday's trial. Donald Trump didn't want that trial on Monday. So he ran into court over a week ago and he sued the judge, of all things, which I'm a lawyer for 32 years. I've never sued a judge. I haven't always appreciated or liked some of the rulings I gotten from judges, but that's the way the cookie crumbles, right? You don't sue the judge. They sued the judge to the Appellate Court, and they said, "Oh, this judge is screwing up, and he's not applying your rulings properly. He doesn't know what he's doing, and please help us. And we can't possibly have a trial on October 2nd because he hasn't even ruled on the summary judgments yet. We have to give Judge Engoron more time to rule." And the judge was like, "I'm the judge. I'm going to rule on it well in advance of the trial." We said on Legal AF, the leading podcast in this area on law and politics, that they don't have to worry about the October 2nd date. We thought the summary judgment was going to be enough and that he was going to rule against Donald Trump, forget the trial. And that sort of happened, except there's counts left over that need to be tried. Now, the judge tried to convince the attorney general, why don't you drop the other counts and we'll just deal with the persistent fraud that I've already ruled in your favor. And the attorney general, give them credit. They said, we can't drop the other counts, Judge. We know you want to streamline the trial for Monday, but we got a big case to put on with 34 witnesses, lots of evidence, and we're seeking some really serious corporate death penalty type sanctions against Donald Trump and his people. We're banning them and barring them and preventing them from operating in New York. We got to put on our case. And the judge said, yeah, I sort of see that. We can't streamline it. See you on Monday, ladies and gentlemen. That's when we start trial. So the appellate court that just ruled, all 5 judges in a literally 3-sentence order, denied the motion to stay. And I'll tell you why they did it, so it's not that much of a surprise. You'll hear on other outlets that there was a denial of the motion for stay. I'm going to tell you why. The grounds that they used to get the stay on the Trump side was, the judge seems to be a little bit out of control and doesn't seem to be applying your orders previous appellate orders about certain issues in the case that got issued in the summer. Can't tell. We don't think so. And he needs more time, and there needs to be a bigger gap between the time that he's going to consider the summary judgments and the trial. Let's give him 3 weeks. And it's really hard, and we need more time. And I'm sure the appellate panel said, all right, well, it's on my watch, it's Thursday. And on Tuesday, the judge granted the motion for summary judgment. So we don't have to give him more time to do that, which he's already done. So it sort of mooted the whole argument. That's one. Secondly, appellate courts don't reach in and try to guide or sanction or influence a trial judge before the trial judge has even made a ruling. You don't like the ruling that Judge Engoron just issued, this 34-page single-spaced rule. You don't like it? That's okay. You don't have to like it. You can file your appeal with the First Department, and you'll get what's called a merits panel of 5 other judges, not these, that'll be randomly assigned, and they will and they'll go for it. And that's it. If you win, you win. You lose, you lose. If you win, it'll go back down to the trial court. It'll get tried again. If you lose, you're done. The chances of you getting to the highest court, New York Court of Appeals, is pretty slim pickings. And so that's what you do. You don't in the middle of the case jump out, sue the judge, try to get the appellate court to admonish the judge before the judge has done anything. And now the judge has done the thing that they were worried about him doing. He already ruled on Tuesday. So there's nothing to stay. So what is the upshot of all this? 5 judges or justices of the New York First Department Appellate Division who sit on top of Judge Engoron. They're like his boss. 5 random judges took a look at this and said, nah, you're going forward on Monday. I'll just tell you, the panel was not great for Donald Trump in New York of the justices that were picked. I know people sort of like this kind of stuff. Justice Troy Weber, one of the justices, used to be the deputy bureau chief for the city of New York's lead counsel. So he's already a municipal kind of attorney general type person and was an assistant district attorney in the Manhattan DA's office. Lizbeth Gonzalez, she was the first attorney general for the New York State Law Department. So she was basically in the attorney general's office. And I could go on. Justice Mendez, when he was a state court judge like Judge Engoron, he presided over the longest trial in the history of New York. It was a crane collapse disaster that he presided over. So he's really not going to be very amenable to an argument that some group needs more time in order to defend themselves in a civil fraud case. So that's the reality where rubber meets the road in New York when it comes to Donald Trump. Alan Weisselberg, the CFO, disgraced, who went to jail for 6 months. Jeff McConney, the controller for the Trump organization. And these people, some of these people, are going to have to take the Fifth Amendment. Because as we said on Legal AF just yesterday, there's a chance that Alvin Bragg, the Manhattan DA, revives his prosecution and goes after the Trump organization following in the footsteps of Letitia James. We know that those two groups, the Letitia James group and the Manhattan DA group, have been working hand in glove on this case from the beginning. There's people in each Letitia James had people that worked in Manhattan DA's office at the time. Manhattan DA had people work at the New York Attorney General's office at the time, all about Trump. Could happen. And that means Alan Weisselberg and the others who haven't testified better think about taking the Fifth Amendment. Donald Trump already waived his because he decided he was going to go in and bamboozle who he liked to chastise and a racial slur and call peekaboo James. They already waived his Fifth Amendment. The other two, if I were them, take the Fifth if you're called. Michael Cohen is going to testify for the New York Attorney General about everything he knows from inside the Trump organization about this scam, this fraud. That starts on Monday. It's not going to be televised. There'll be sketches, but the MeidasTouch Network is going to follow it. We'll do commentary, and the 3 leaders of Legal AF, the leading podcast at the intersection of law and politics, one place, the MeidasTouch YouTube channel, will be there. Ben Meiselas, Karen Friedman-Agnifilo, Michael Popok. Until my next hot take, until the trial starts on Monday and Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.